Good morning, everyone. My name is Jeffrey Hull. I am the Talent Development Director with Employers Group. I'd like to welcome you to today's webinar on SB 1343 compliance. What is it and how do we comply? With me today is Mark Nelson, Employers Group Senior Helpline Consultant. Mark, are you with me?
I am.
Okay, great. Thanks for affirming that. So it looks like we're ready to go. We are still expecting a lot more attendees to join today's webinar. Before I begin the presentation today, there is a chat dialog box. If you have any questions during the presentation, feel free to use that chat dialog box. And when you're filling in that chat, feel free to share your question with the entire audience. That way, the entire audience can see the questions that are coming in. So just to orient you to where the chat window is, I'd like you all to go there now and just answer this question. Did you do any harassment prevention training in 2018? If you did, type yes. If you did not, type no. So go to the chat dialog box and type in yes if you've done training in 2018 and no if you did not. Okay, I'm not sure if people are able to type in, so I'm going to go ahead and begin today's presentation. So with me, once again, is Mark Nelson, our Senior Helpline Consultant. Today's agenda is going to cover quite a variety of different topics, all dealing with harassment prevention training requirements. The very first one is that we'll be covering is regarding employee and supervisory training requirements. You all have familiarity with the AB 1825 training requirement. The SB 1343 requirement supplements that supervisory requirement, and we're going to specifically talk about that a lot today. We're also going to be going over some harassment policy requirements. Both the DFEH and the EEOC have provided guidelines on what should be in your harassment prevention training or harassment prevention policy. On your handouts tab, you'll find the sample DFEH sample policy, so you can go ahead and download that. Also on the download screen or handout is a copy of today's presentation for you to have afterward. New for this year are some definitions on national origin and also gender-related discrimination. The new harassment prevention training requirements, SB 1343 and also SB 1300, specifically address gender-related discrimination and call that out as a requirement to be included in your harassment prevention training program. So we'll talk a little bit more about that. We'll also go into altered working conditions. You probably all have heard severe and pervasive. Well, the state has changed that, and they've really changed that to be more loose. And they focus now on what conduct alters working conditions. So we'll also talk about that. We'll go into the expansion of liability for harassment conducted by non-employees. Then we'll wrap up today's presentation with bystander training. What exactly is bystander training, along with employer defamation protections. So we'll jump right into what is SB 1343. You're probably all sitting on the edge of your seat waiting to find out what exactly this is. Some of you may already know what it is, so we're going to go a little bit more into the definitions of it. So if you're an employer with 5 or more employees, you're now required every 2 years to provide at least 1 hour of harassment prevention training to employees and provide at least 2 hours of harassment prevention training to supervisors. So that all familiar AB 1825 requirement. It must be completed by January 1st of 2020. So that means you basically have 3 quarters of the year to get it finished. It's for all supervisors and employees. One interesting note is that within 6 months of assuming a position, so if you hire an employee, they need to be trained within 6 months of being hired, or if you promote somebody into a supervisory position, they must be trained within 6 months of assuming that position. That's very similar to the AB 1825 requirement. One new requirement is if any of you have temporary employees where their employment lasts less than 6 months, you will need to do harassment prevention training within the first 30 calendar days after they're hired or within the first 100 hours worked. Fortunately, that requirement does not go into effect until after January 2020. So that does not currently apply to you, but training all of your current supervisors and employees are required, as well as having a plan to do harassment prevention training for new employees within 6 months of their hire date. One really confusing part of the SB 1343 language is there's specific language in there that says this provision is not required if you provided training after January 1st, 2019. There's been lots of discussion about whether that was a mistake. The DFEH has come out and basically said, if you did supervisory harassment prevention training last year in 2018, you must now still provide harassment prevention training to your supervisors in 2019. So in essence, this is resetting your harassment prevention training clock. So if you were on the odd year approach in 2017, 2019, you're in luck because 2019 is when you need to do training. If you were on the even year harassment prevention training schedule where you did training 2016, 2018, 2020, unfortunately, you will need to do training in 2019 per this new law. So it does have a really big effect on California employers that did training even December of 2018, because now it basically is required that you do harassment prevention training for all employees in 2019. So a little bit the difference between SB 1343 versus AB 1825. SB 1343 is for 5 or more employees. So if you had 20 employees, you did not have to do harassment prevention training. AB 1825 was for employers with 50 or more for AB 1825. Now the threshold is down to 5. So it really affects every employer in the state. SB 1343 is specifically geared toward employees, whereas AB 1825 was specifically geared towards supervisors. The state really mandates what's contained or what's required in the training programs, so that really doesn't change. One thing that's really a difference between SB 1343 and AB 1825 is the definition of trainer. Under SB 1343, when you're doing employee level training, it loosely defines a trainer and the delivery approach, and we'll go into that in a little bit more detail. Whereas AB 1825 related training specifically defines who's a qualified trainer and the delivery approach. So, you probably used specific AB 1825 trainers in the past that will still hold true when you're training supervisors. However, when you're training employees, that's loosely defined as anyone that has knowledge on harassment prevention. Both have specific tracking required, and which we'll cover in today's presentation. The delivery modes for SB 1343 are really undefined, whereas the AB 1825 requirement specifically said that the training must be delivered by an instructor, via e-learning or via webinar, and that must be interactive, whereas the SB 1343 really doesn't define that, so it lets the employer really determine what would be the best approach. So it does say for SB 1343, and this is the employee level training, it shall include information and practical guidance regarding federal, state, statutory provisions. So all of the basic information that is contained in the typical AB 1825 training really needs to be included in your SB 1343 training. The real focus for any type of trainings when you deal with harassment prevention is really on the prevention and correction of sexual harassment. They want people to be aware of when sexual harassment is occurring and what to do to rectify that before it becomes a significant issue, and a possible liability for your organization. They do want remedies available to the victims of harassment to be covered. So anything that would be available to a victim of harassment, whether it be during an investigation or even after harassment is found, what are some of those remedies available to them? Once again, we have the pesky abusive conduct. It needs to be a component of the training. And the real rationale for the abusive conduct is to really surface bad behaviors that are going on that's on the fringe of maybe becoming a hostile work environment claim. So abusive conduct, while it's not a legal protection, the state does want employers to be proactive and just surfacing bad behaviors that could result in a potential claim of liability to your organization. In SB 1343, it specifically calls out that gender identity, gender expression, and sexual orientation must be included in the training. So, the 1 hour training is really getting packed full of information here, as you can see. And then while we talked about SB 1343, last year the state was really busy, coming up with a lot of harassment prevention regulations. Another law that really affects employers is SB 1300. It authorizes but does not require that employers provide bystander intervention training to employees. So we'll talk a little bit more about that in today's presentation, but it is definitely a best practice to include what the state is recommending to be included in your training, even though it doesn't require it. It's just one of those proactive employment measures to take. So what is bystander intervention training? So, this really comes out of higher education in a lot of respects, but a bystander is present and notices a problematic situation, and they take on their personal responsibility to take action to intervene with the goal of preventing the situation from escalating. So a lot of times, in higher education, they've taught this concept of bystander just to prevent violence and some types of bad behavior there. So they want this to sort of go on into an employment situation. So if somebody sees somebody behaving poorly, that's really fringing on harassment or discriminatory behaviors, they do want the employee to speak up. So even if it's not the victim or the target, anyone that notices that. So what does a bystander do? They can distract, they can get help from others, they can check in with the person that was the target of the behavior later on. They could be directly intervening, saying something to surface and stop the issue. So, the purpose is for them to actually stand up against the bad behavior. So one of the best practices for doing the SB 1343 is to provide instructor-led training. That's probably the better approach to doing this. What you'll need to do is make sure that you have a sign-in roster. You want to document the attendance. You want to have that original documentation. You do need to provide the DFEH brochure on sexual harassment, and we'll provide a link of that document to you after today's, as well as the brochure on workplace discrimination and the brochure on transgender and gender discrimination. And of course, when you're doing instructor-led training, it's always a good time to include your organization's policy in the program itself. It's a good time to review some of those key provisions in the policy. And once again, we have uploaded as a handout the DFEH sample policy that they have created. And once again, their policy is quite voluminous. There's many pages to it. And then one thing that we recommend is to sign an acknowledgement form by each trainee or each attendee in the program. That's in lieu of a completion certificate. It actually is much better than a completion certificate because they're affirming what they learned in the training program. Completion certificates, if it doesn't have a lot of information, is not really valuable to the attendee or the employer. So SB 1343, as I said, it really loosely defines who can do harassment prevention training for employees. So they must be trainers or educators with knowledge and expertise in the prevention of harassment, discrimination, and retaliation. They also need to have knowledge and expertise on gender identity, expression, and sexual orientation. So, assuming that the crowd on today's webinar are all HR practitioners, most of you have knowledge in all of these different areas. So, you probably all would qualify as a trainer to do employee level training. However, for AB 1825, you might not have the specific knowledge. I don't have the trainer requirements up for the AB 1825 requirements because it's something that you've been doing for a while already. The DFEH is to develop training materials to help individuals train on harassment prevention. They actually created an employee level PowerPoint presentation and it's posted on their website. Unfortunately, it has over 100 slides and there's no trainer notes involved in that. So if any of you are familiar with instructional design, doing a presentation, 100 slides for a 1 hour time frame is a lot of slides, to say the least. So, it would require a lot of your time to actually go in and revise those slides to be within the time frame that you'd want to do training. From an instructional design standpoint, for 100 slides, that would equate to probably a 2 hour plus training program from my perspective. So 100 slides is a lot to get through. The DFEH is also to develop online courses, and there's no time limit set for when that will be done. Tracking has always been a really big issue with harassment prevention training. Even employers group, tracking it has always been difficult because of the timing requirement. So, there's a lot of people that struggle with that timing requirement, 2 hours for supervisors and 1 hour for employees. So it's unknown how the state is going to be able to have a compliant and trackable solution to that. So there's no time frame on that. So it's really up to employers to figure things out in the meantime. What I'd like to do now is turn it over to Mark Nelson. He's going to touch on the HR practices that you have in place and some things you might want to think about when you're coming up with your harassment prevention practices for 2019.
Thanks, Jeff. I appreciate it. The first thing we'd like to point out is the policy guidance that the DFEH provided us, which is basically a 7 or 11-page sample policy. We generally ascribe to the philosophy that when it comes to HR policies and practices, especially if you reduce them to an employee handbook, less is more, so that you're brief and concise. The two exceptions where we see a longer policy, of course, would be in harassment prevention. So while I don't know that you'll want to have 11 pages of your employee handbook dedicated to harassment prevention, we would certainly ascribe to the philosophy that it be detailed to include nothing less than, of course, what they include in the sample policy itself, which would be discrimination, harassment, sexual harassment specifically, and then, of course, retaliation, followed by a complaint procedure that employees can fill out. You'll note that the sample policy provided by the DFEH does include a complaint form. We only want to condition reference to the complaint form that even if an employee does not complete a complaint form or refuses to participate in the investigation after making us aware of it, or we independently find out about allegations of harassment, we still have an obligation to investigate and dispose of that issue. So while that complaint form is helpful for us to kind of do an intake of what is alleged to have happened, it is not, we don't have to ignore the elephant in the room by virtue of the fact that an individual did not complete that. Please also note that the sample form includes state agencies. And then a final note here, especially for those of you with workforces for whom a significant portion, in this case 10% or more of your employees speak their spoken languages other than English, you do have an obligation to translate that policy into into the language that's spoken. So put that note, put a circle around that one. Moving on to the next page. Promising practices for preventing harassment. This is actually a really a great document and stems from a lot of research that's been done on the requirements to make harassment prevention effective in a workplace. In fact, we facilitate the class for HR professionals sitting for their SHRM certification, and we cover this in great detail in our section on diversity and inclusion, which is one of the components that you're tested on in your SHRM certification. And the one piece that's most critical in every circumstance is a commitment from leadership that they will be engaged and participatory in the harassment prevention. Regrettably, I have had occasions to facilitate harassment prevention scenarios where the executive team sits in the back, asks the most questions that are derogatory in nature, and you've got kind of a communication implicitly that what they're doing is undermining the whole entire purpose of harassment prevention training. Certainly, you as HR professionals want to sit down with your executive team and ensure buy-in from them, and ensure that when they participate in the training, whether it be just SB 1343 or just AB 1825 training, that they communicate their commitment to the company adhering to harassment prevention in the workplace. Obviously, that goes hand in hand with accountability and understanding the policies themselves. The complaint procedure is critical. We can talk about a little bit more about that in just a moment, but also regular and interactive training tailored to the audience. You really want to come up with hypotheticals that illustrate how employees might interact or might be exposed to scenarios that could lead to harassment or might exhibit harassment in and of itself. You want to be able to make sure that your employees are armed with how they might best respond in those situations. Moving on. The EEOC also has some policy guidelines. Obviously, harassment prevention applies to all levels. You want unequivocal statements of the protections. Obviously, that goes without saying. I think I haven't encountered many policies where there are qualified statements, but point being, you want it to be accessible for your employees. So of course, easily understood. Informal sharing also is another factor that comes into play. You want to clearly describe the complaint procedure. Obviously, I'm sure you're all aware of this. We've gone through this with AB 1825 training for years now, but you want additional avenues for employees to complain so that they have access if they do have a concern that they don't want to present with their immediate supervisor, or they're afraid that their supervisor may in fact be the person responsible, or even within their network of contacts or confidants. You want someone outside that as an option for somebody to complain to. In actuality, all managers must be ready to field and escalate complaints of harassment. I can't tell you how many instances we get on the helpline where HR has had to get involved because the manager was approached by an employee who told them in confidence and did not want to escalate the situation. Anytime a manager is involved, it's as if the employer is involved, and for that reason, a manager's refusal to escalate to HR an employee's concern is as if the employer or the HR department itself did not. So making it very clear that while you have these additional avenues, you want all employees to respond promptly. You also want to place a responsibility on employees to respond to or to report questionable behavior. If they witness it and bury their heads, there is a standard called knew or should have known, and that creates a should have known scenario. Obviously, moving on down here, you want prompt, impartial, and thorough investigations. That's something that you always want to ensure you adhere to in any policy on harassment prevention. Also, confidentiality. Confidentiality, in fact, in the regulations here in California, you're required to qualify that confidentiality so that it's not absolute confidentiality, but confidentiality to the extent practicable, simply because obviously if you give the accused an opportunity to tell their side of the story, you may have to detail the circumstance that gave rise to the complaint. If that circumstance involved only a few actors, when you put that circumstance in context, you may have to place employees in the room, meaning they're no longer their complaint is no longer absolutely confidential. Moving on with this, basically, all of the policy guidance principles that the EEOC has outlined are pretty standard and par for the course. So with that being said, I'm sure you've encountered these already. I won't belabor the point. Let's move on to the next slide. Okay, so national origin discrimination has received a lot of attention most recently. We have a lot of concerns for individuals in protected classes based on national origin who have been victims of or have been targeted for their association with individuals in a particular national origin, or themselves coming from a particular national origin. And being the victim of harassing behavior because of it. This is clarifying and giving new import to the importance of HR professionals being aware of this when facilitating harassment prevention classes, as well as when they're investigating complaints themselves. We've always had association discrimination, which is basically this concept that if, for example, I'm married to someone of a particular national origin that is being targeted for harassing behavior, even though I myself am not in that of that national origin, my association with someone who is provides a basis for legal action. So you want to make sure that you're responsive in all cases where individuals are using derogatory terminology to reference individuals' nationalities, their ethnicities, anything where we have individuals who are essentially being victimized because of where they come from or the associations that they identify with. Also, membership in associations is getting a lot of prominent receiving a lot of attention now. Membership in the Me Too movement and individuals who are being targeted because of their affiliation with someone, organizations like Me Too. You want to be very responsive as an HR professional, investigate and dispose of those issues immediately. Obviously, this also crosses over into a lot of religious-based discrimination as well. So national origin and religion going hand in hand. Be sensitive to all of those issues. And then moving on. We also have gender-related discrimination. This is, the regulations that were recently passed clarify quite a bit regarding how we are expected to be approaching this from a training perspective, as well as from an HR perspective, when dealing with individuals who express their gender differently than that assigned at birth. In the definitions matter, and so we want to make sure that you're aware of how these are defined. Gender expression being the internal identification of someone based on a particular gender, or non-binary genders. That basically meaning they don't identify as strictly male, they don't identify as strictly female, but rather on a scale in between that. Gender identity is how they express their or gender expression is how they express themselves. I'm sorry, gender identity is how they internally envision themselves. These are both to be distinguished from sex, which is the biological construct, typically associated with the social construct of gender. Not associated, but distinguished from, I'm sorry. Anyway, let's obviously with gender identity issues, we want you to be sensitive to the idea that when it comes to gender identity, we're moving away from in policy language and in the way we interact with individuals, moving towards gender neutral language in things like employee handbooks and other documents, especially for those individuals who do not identify as strictly male or strictly female. And that's kind of the wave of the future. That's where we're headed. And so we're just hoping that if you're looking at your policies, you're looking at that with that frame of mind or reference point. Great. Moving on. Severe and pervasive. So this is the good thing about what I'm about to talk about is that it really doesn't apply to how you will be interacting with your employees. You know, whether or not it's a single instance that disrupts their ability to perform their job, or whether it meets the standard of severe or pervasive, you don't want to get into the weeds with your employees with regard to investigating claims of harassment. If an individual feels like they are being subject to harassment, whether or not that rises to the legal standard of harassment and therefore is actionable, you are still going to investigate that complaint regardless. These are arguments that are left up to your attorney. Obviously, the change from severe and pervasive to a single incident of harassing conduct, which is now the new standard that creates a tribal issue on the existence of a hostile work environment, the new standard being unreasonably interfering with an employee's work performance based on that one instance, and that giving rise, that certainly makes the company more exposed. But you, as an HR practitioner, will always investigate claims of harassment. So while this does change the dynamic, if you do have a case escalate to trial, we want you guys as HR professionals to essentially be looking into every instance and investigating those instances of harassment regardless. This is basically just a reminder that when when we're made aware of harassing behavior, we're immediate and responsive to that claim or complaint. All right, moving on. Also, you know, going back a few years, and I'm dating myself by doing this, but I remember when I was first entering the space, going out to client locations and encountering in like a garage environment, inappropriate monthly calendars and those like the things of that nature. Obviously, that would be inappropriate under any circumstances, but you can't have we can no longer assert the argument that this is a production floor, people are confrontational here, they joke around, they don't mean anything by it, it's just the way it goes, everyone hazes the new hire, and they figure out a way to kind of rib them, and obviously if that's on the basis of any protected classes, it doesn't matter, it's not appropriate under any circumstances. We are no longer in the 90s when I was kind of entering the scene. Things have changed. You cannot behave in that way any longer. And employers can't just say, well, it's manufacturing, it's the way we expected, it's the trucking industry, people just behave like this. Those are not defensible arguments. They never were technically, they certainly aren't now. Obviously, non-employees. Jeff mentioned earlier SB 1300. We want you to be investigating all allegations. In circumstances where your employees are being exposed by non-employees, or if you have individuals affiliated with you as interns, volunteers, etc., those claims need to be investigated. It's always been the case that we recommended that you investigate these. Now it's obviously solidified by SB 1300, but we're about eradicating harassing behavior that any of your employees might be exposed to, or anyone affiliated with the company. Obviously, that's destructive to any sort of productive working environment, and this just kind of brings that home. With that, we kind of move into another component in terms of new developments. I will say, despite the fact that you are allowed to give your opinion about a former employee as to whether you would rehire them, with this point, we still are kind of seeing a trend of not employers not offering more than name, rank, and serial number. Obviously, no longer their salary as well. But this is out there for you to do with it what you will. With that, I will hand it over back to Jeff.
Thanks, Mark. And I agree with you too about employer defamation practices that employers can now, say about somebody's conduct, specifically with harassing conduct. Definitely, it's just something that is still untreaded water. So you probably want to stay away from it, even though the state specifically now allows you to surface that with a potential reference check. We do have a couple questions so far, and I think it's a really good time to address those. One question came in that we have 4 employees and the owner. Would we qualify, or would we still have to do this? Yes, that does meet the 5 threshold with 4 employees and 1 owner. It's 5 total, so you would have to do harassment prevention training. Another question came in regarding whether this was for full-time employees or part-time employees. From our reading of the law, there's no differentiation between part-time and full-time. So if you have a company and you have 4 part-time employees, you would still be subject to this. Mark, is that your interpretation as well?
I would read that. Yeah, I would read that the same.
Okay. And then one other question that came in, and I'll let you address this one, Mark, is regarding temporary employers or employment agencies. Are they required to provide this training to their employee pool?
In that regard, yes. That might be a conversation we take offline. There are some additional considerations that you have to take into account, and I would want to address those in more detail.
Okay, yes, and I would say, just as a practical standpoint, the temporary agency should be doing this training because they're a joint employer. So I believe that they should be doing that anyhow, but we can definitely take that question offline. So you can feel free to use the question dialog box if you have any additional questions that you want to ask during today's presentation. And I just want to double check to make sure that there's no other questions there. Okay, and we're going to move on. So now what? Now that you have this information, probably information you did not want to receive. So now what do you need to do? The first is really to secure executive level commitment. This is an onerous requirement subjected to California employers by the state, but look at it as an opportunity. So don't have attendees going into training, dreading the training or making it look like a chore. It's really getting that senior level executive commitment. So, the crowd that's on the phone, I really give you guys kudos for taking time out of your day to learn about this. But by you championing this effort on harassment prevention policies and training requirements, you really do show your commitment to all the employees that this is really important to ensure that your company is harassment free. Also, make sure that your harassment policy is compliant. You'd be surprised how many times we find harassment prevention policies that are not compliant. So, those really need to be reviewed annually to make sure that you have all of the specific protections listed in them. That's a really important requirement, one that we just overlook in a lot of respects. So, take a look at the state sample that we provided. And then we also have lots of different samples at Employers Group. So you will need absolutely to provide 2 hours of AB 1825 compliant training to all supervisors this year. Even if you did it December last year, per the state requirements and the DFEH interpretation of this new law, you will need to do training for everyone in 2019. You will need to provide 1 hour of training to all employees. There is specific training content required there, and you will need a knowledgeable instructor. And like I said, a lot of you HR professionals would be knowledgeable to be able to do that. You also really need to think about a way that you will create a turnkey and compliant way to train all of your new hires, those that you're promoting, with the appropriate harassment prevention training. A best practice is to really include harassment prevention training as an onboarding experience for a new hire or a new promotion, just so that they're fully aware of all of the requirements, just like you'd go over your policies with them. An important requirement is to document and retain records for 2 years. And I'll talk a little bit more about that. The state specifically says to document it and retain it until the next time you do training. In itself, that's a little problematic. So I'll explain why that's problematic. So what to retain? Any forms that are signed in class. Have the signed version, but also have an unsigned version that's in your file. Any documents that are referenced in class. So if there's a training materials or handout materials, definitely want to reference that in your training file. Have the instructor and training agency information. It's always good, even if you're doing employee level training, to indicate who did the training internally for your company and what their experience was, because somebody might leave the organization and you want to be able to have all that information within the file itself. Any training materials, any handouts that are provided, definitely keep a copy of that, even if it is the DFEH documents. You definitely want to have copies of all that. Attendance rosters, the state specifically says you need to retain them until the next 2-year period. That can be problematic because once that next 2-year period comes around and you get a notice of a complaint from the DFEH or even the EEOC, the very first thing they ask you in that complaint is to provide the documentation to support that you did the training. So if the complaint was from, let's say, I'll use this year as an example, if it was from 2019 and you just did your 2019 training for 2 years from now, but you threw away all the materials from 2017 and 2018, how are you going to document that you did the 2018 training? So the best practice would be to keep the attendance rosters for 2 cycles. For 4 years, basically, would be the best practice to keep those attendance documents, because you have to really look back on the statute of limitations on how long it can take somebody to actually file a claim or complaint to the DFEH or the EEOC. Track attendance on a spreadsheet. That's really a recommended approach to make sure that everyone's recorded. If you have a learning management system, make sure that you track that. Make sure that you have the employee name, the training they received, and the time and date that they took the training. All really important things to have. One question we do get is this required for if you have 1099 contractors? Mark, I'll let you jump in on that one about if you have 1099 contractors, should they receive harassment prevention training?
1099s are definitionally not employees, so they typically fall outside the scope of AB 1343 training, but they are impacted by harassment prevention. In other words, you have to protect against independent contractors who might be experiencing harassment prevention. The extent to which I would roll them in, I would probably want to have a conversation with my counsel about that, just to make sure that we're not blurring the lines for the employer independent contractor category. Although you have to investigate complaints about either harassing behavior by independent contractors or that independent contractors experience.
Okay, thank you. And then another question, is there anything we must change in our existing harassment policy if it was compliant back last year?
Things that you're going to update it with what we just talked about today, making sure that you incorporate the new regulations regarding national origin, as well as with regard to the gender identity, gender expression issues.
Okay, great, thank you. And it's really interesting to go through that DFEH provided sample policy. It is a long read, but it might give you some new or fresh ideas to incorporate into your specific policy. So I definitely recommend that. We talked a little bit about retention of records. I'm going to move on to, a lot of organizations are using e-learning now. Employers Group is an e-learning provider, so we're going to share some best practices with you. Whenever you're looking or reviewing a content, make sure that you have a checklist on what's required for the AB 1825 and also the SB 1343 training requirements. So you want to make sure that it contains everything that the state requires, and also that it contains everything that's recommended. Recommendations are that bystander training. You definitely want to be best practices when you do any training program. So make sure that it includes, abusive conduct, the bystander training, the gender definitions, the transgender, the national origin, definitions. And then also make sure that it uses technology to track that minimum time requirement is met. That's probably one of the biggest issues with harassment prevention training, is that minimum time requirement. A lot of LMSs find that problematic. So make sure that you find out how that LMS tracks that, because it is a really important requirement. Adults don't like to be told. This is the most telling that we do in any of our training programs is in a webinar, because there's so much information we want to give you. But you need to engage learners in an engaging way. So however you do that, you want to engage them. So instructor-led training is typically a really great way to do that, but e-learning must engage them as well. Make sure that your e-learning incorporates your policy. When you do any training, it's really important to connect your organization's policies and procedures with the training that they're going through. So make sure that that learning program incorporates that. Also, make sure that it's done by reputable companies and done by qualified instructional designers. They will ensure that the training is done in an engaging way. So, definitely ask questions about how the individuals that developed it are qualified as far as meeting the instructional designer requirement. And that it includes the tracking of reports to substantiate completion. All the time we get, will the system generate completion reports? I look at companies with 500 employees. Do I want to print a ream of paper, or do I want to have all of that into one spreadsheet that has all of my 500 employees on one spreadsheet? I would rather go with a spreadsheet with 500 names on it versus a whole ream of paper. So, you want to be able to have reports that substantiate that completion rather than relying on that completion certificate. Also, the state does not require this, but we do recommend it, a proficiency exam. Proficiency exams are really important because it measures learners' knowledge on the topic. If your e-learning does not have that, I'd suggest that you find another provider because it really is a golden opportunity for you to be able to see if somebody's just clicked through the material and did not learn anything versus, do they have a thorough understanding of the content? And we definitely want people to have a thorough understanding because they need to understand what behaviors are acceptable and what behaviors are not acceptable within the workplace. So I'm going to talk a little bit about some of the Employers Group instructor-led solutions. Most of you on the call are longstanding clients with Employers Group. We do offer instructor-led training. That's what we recommend the most. You can actually order instructor-led training at our website. We've actually discounted it significantly if you order it online. And so to have an instructor come out for 3 hours, it's $1,150. To have an instructor come out for 5 hours is $1,650. So you can do any combination of employee level or supervisory level groups for those prices. One thing that's brand new this year, and we are really excited about it, is a do-it-yourself kit. You get this for free if you have any of our instructor-led solutions delivered for your supervisors, let's say. Why this do-it-yourself kit's really great is that it allows you to actually do the employee level training. We've recorded a webinar. You can stop, start, and pause it accordingly so that you actually get the training engagement. So if you have another solution for your supervisor training, you can just get the kit by itself to be able to do the training yourself on harassment prevention. And then we also do custom training solutions. We do training throughout the country in a variety of different states on what harassment prevention training requirements are for specific states. So if you want us to do that, we are more than happy to. For custom solutions, we'll do customized materials. We'll review your harassment policy. We could deliver it in English or Spanish. We could deliver it internationally. We do have programs in Australia, the UK, and Canada. 24/7 shifts, etc. If you have any legal directive from the EEOC or DFEH, a consent agreement, we can deliver that for that. And then for e-learning, this is a really important one because e-learning is a way that a lot of companies are choosing to comply. With our e-learning solutions, we have 9+ as our standard solution. So you can see we have all those listed on the screen. We also have versions available in Australia and Canada. So we are definitely have an international flair to that. So e-learning, when we talk about e-learning solutions, we are the lowest cost e-learning provider that we've seen. So our courses are only $40 for supervisors, $35 for employees, and volume discounts apply at $20 at myeglearn.com. But the better approach would be to implement a more comprehensive solution. It's actually lower cost. It's called e-training portal. I recommend that you go there. If you have more than 50 people to train, it's probably the most cost-effective solution because it includes all 9 of the courses that you see here. So you can, if you have employees spread around the country, you can pick whatever modules you want. So it includes all 9 of those harassment courses plus 20, 50, or 70 others. And again, all of our courses are modular, so you can actually deploy that on your learning management system. So we can put it on any of those. For e-training portal, the cost is just for up to 100 learners is just $1,950. That just equates to $19.50 for you that like the math. So that's a really low cost solution. You can go to etrainingportal.com to learn more about that particular solution. We can also customize a URL. So it could be your company name.etrainingportal.com. And if you implement eTraining Portal by the end of March, we will waive the setup fee if you're not a member. And of course, if you're an employers group or everything HR member, you enjoy a no setup fee all the time. So with that, I wanted to get the presentation done before the hour was up, and we were able to do that. We will stay on with any questions anyone has, and you can type those in the question dialog box. But if you do not have any questions, we want to thank you for attending today's SB 1343 webinar. If you do have any questions after today, you can email us at training@employersgroup.com, or if you want to purchase one of our solutions, you can go to www.employersgroup.com. Thank you for attending today. We will stay around for any questions anyone has. We did have one question regarding, and this is actually a good question. So Mark, if you have any minors attending the SB 1343 training, so that would be individuals under the age of 18, would you recommend seeking parental consent?
As a general practice, we always recommend that if you're engaged in anything, like minors can't consent to contracts. They can't do other things that, like they can't complete their Form I-9 by themselves. Generally speaking, I would want a consent from the parent before subjecting a minor employee to the harassment prevention training, just as a general concept. Yes.
Great. That was a wonderful question. I learned
Yeah.
something. Thank you, Mark. And thank
No
you,
problem.
Brenda. So we will hang out with any other questions, but if you do have a question you want to take offline, you can feel free to email us at training@employersgroup.com and we'll be happy to answer it for you. And if you have any questions regarding purchasing harassment prevention training, feel free to also email us and we'd be happy to conduct that for your company. That will conclude today's presentation. Thank you once again for your kind participation and involvement in today's webinar. We hope it was informational and we wish you a great rest of your week. Thank you. And thank you, Mark.
Thank you.